Be ready, start. I am extremely glad to be present here at the valedictory session of the Platinum Jubilee celebrations of Income Tax Appellate Tribunal. The tribunal, which was set up in 1941 to function as an impartial quasi-judicial body to resolve the disputes between the revenue and tax-paying public in completing 75 years now. The concept of tribunals has been borrowed from the French judicial system, which had a set of administrative courts that run parallel to the civil courts. The intention behind this system was to ease the civil courts from administrative matters while laying separate standards for administrative disputes. The modern Indian Republic was born as a welfare state, and thus the burden of the government to provide a host of welfare services to the people was immense. The quasi judicial powers acquired by the administration led to a huge number of cases with respect to the manner in which these administrative bodies arrived at their decisions. The vast number of welfare legislations, coupled with the right to judicial review, was thought to burden the civil courts with more matters than they would be able to handle. Thus, various tribunals for income tax matters, railway rates, labor matters, and company courts were given statutory legitimacy to function parallel to ordinary civil courts. Para. The French system of tribunals is in contradiction to the rule of law, where everybody in a state shall be subjected to some common law, and there is no need for extraordinary tribunals to deal with cases of government and its servants. As per rule of law, it was unusual that when the injured individual sought protection against the administration, he had to turn to an administrative body which was certainly closer to the administration than the judicial courts. In India, the adjudication of administrative disputes has been committed by the judiciary through various cases placed before it over a period of time. As of now, we understand that a complete adoption of French system is not possible in India because judicial review of tribunals orders cannot be fully removed, with judicial review being an integral part of our constitution. Para. While the matter seems to be put to rest with Supreme Court's famous decision in Chandra Kumar's case, the debate has not ended yet, and much remains to be debated in the context of working independence and efficacy of the tribunals. There have been many success stories of the tribunals, yet there have been instances of delays and favoritism as well, though the courts have consistently held that these bodies must maintain procedural safeguards while arriving at their decisions and observe principles of natural justice. Yesterday, during the inauguration of Platinum Jubilee session, when Honorable President of India was also present, I here briefly touched upon the criticism of the tribunalization of justice from some quarters. Para. While in some quarters increasing tribunalization has been criticized, as an encroachment of the on the judiciary independence and contrary to the constitutional scheme of the separation of powers between judiciary and the executive. Stop.